Before we specifically talk about the FISA statute, let's talk a little bit about some history and some constitutional law about the federal government's ability to use surveillance techniques in the context of national security involving U.S. citizens under the Fourth Amendment. And this is the U.S. District Court, Eastern District of Maryland case that I gave you. The caption of this case is a little bit weird. It's set up this way because it was a petition for mandamus that went up on appeal and then went up to the Supreme Court. So as you read this case, you can see a little bit of the background. The case involves this guy, Lawrence Plamondon, and you can see on the slide here a relatively recent, within the past 10 years or so, picture of him. He was a lot younger, obviously, when all these events happened, but he was a kind of well-known radical activist hippie in the 1960s. He was a founder of an organization called the White Panthers, which was a organization that was supporting the goals and aims of the Black Panthers in the 1960s, which of course was a radical African-American organization that at times even advocated the use of violence to deal with kind of the racial tensions at the time. Plamondon was allegedly involved in the bombing of a CIA recruitment office in Michigan, and I gave you a link to some of the background materials. Nobody was injured or killed in that bombing, but the office was damaged, some records were destroyed, and so on. Well, the government had information about Plamondon's alleged involvement because it had wiretapped his phone conversations, and it was phone conversations between he and members of the Black Panthers, and the government had done that wiretap without a warrant, so had done it without going under any wiretap statute or any other warrant requirement. And the government's argument was that the Black Panthers and the White Panthers and all of these radical activists at the time were presenting a national security threat, and in fact were threatening the stability and safety overall of the U.S. government, and that therefore the president had the authority under his inherent executive powers to engage in this surveillance activity without having to go to the judicial branch for a warrant. Incidentally, Plamondon was the first hippie on the FBI's 10 most wanted list. He became a fugitive after that CIA bombing and after he had been charged with this offense before this case eventually got litigated up to the Supreme Court. To me, this is a really fascinating case. It illustrates, I think, once again, that nothing really is new. Most of you didn't live through the 60s. I was just an infant during the 60s, but kind of having a little bit of a sense of that history, the late 60s, mid 60s, early 70s. And we know it, of course, as the time of Woodstock and all of that sort of thing. We tend to think of the hippie culture, the counterculture of that time today in sort of heroic or nostalgic terms. But there certainly were elements of that culture in that time that were considered highly suspect. There were at least some extreme elements of that culture, I think fair to say, a very small minority who did advocate violence and so on. But there was an enormous culture clash over whether these people were subversive of the government and over the kind of scope and extent of the ability of the federal government to conduct surveillance activities on them, which they did to a very extensive degree. So this case eventually finds its way up to the Supreme Court, and you can frame the issue as whether there is judicial approval required for national security surveillance. And I should really have added to this slide national security surveillance that involves the surveillance of U.S. citizens. Because, of course, if it's simply a surveillance of foreign citizens, the foreign citizens don't have the same rights as U.S. citizens under our Constitution, and there's a different set of rules that would apply, really international law rules. So we're talking about surveillance that involves U.S. citizens. So the U.S. Supreme Court first of all, it looks at the wiretap statute as it existed at the time. And the wiretap statute has some specific language that indicates that the statute does not limit the president's ability to do what the president needs to do and is able to do under the president's inherent national security or war powers. So the government's argument is that the president has this inherent power and that the statute carves out this inherent power. And ultimately, as you see from reading the opinion, the court disagrees. And what the Supreme Court says as well, all the statute is doing here, it's kind of like a savings clause. It's just saying the president's powers are the president's powers. But what we're doing here is specifying certain conditions under which the government can surveil American citizens. The portions of the statute that deal with surveillance require a court order. It is true that the court recognizes it is true that the president has the fundamental duty to preserve and protect the United States, and that it's really a kind of core question of the executive's function to protect the people against subversion and war. And indeed that it may be necessary for the federal government to use surveillance in order to protect the national security. And in fact, the Supreme Court says there's nothing astonishing about this. We're not surprised that the government uses surveillance in the exercise of this power. And in fact, such surveillance has been used and sanctioned specifically by U.S. presidents and attorneys general since World War II, really. So that's not surprising. And the court further notes that, and remember, this is 1972, events that are occurring in the 1960s, and already the court is talking about the complexity of these activities, the ability of conspirators to use electronic means like the telephone networks to carry out their plans, and so therefore there can't be a blanket rule against surveillance of the telephones. But the court says, recognizing all that, there has to be a balance with the requirements of the Bill of Rights. There's always this tension. The court doesn't use exactly these words, but the thread underneath this, there's always this tension between liberty and security. And so we've got to figure out how to balance those things in this context. And the court notes these cases that involve questions of national security very often are going to impact on core First Amendment values, because the government is often going to suggest that people who are speaking against it are subversive, and that as people speak against the government, they threaten the government, and that therefore national security would require the government to surveil them and perhaps in some way to limit or shut down their activities. And this is a problem. This is one of the things the First Amendment is originally designed to safeguard, the ability to criticize the government. And we can't allow the legitimate need for security and the legitimate need for certain kinds of surveillance to put a chilling effect on vigorous debate, vigorous discussion. All of these are, of course, very familiar First Amendment values and very familiar kinds of things that we have to balance in this sort of context. So the court says, kind of the judgment of history, the weight of history under the Fourth Amendment is that if the executive is able to carry out this kind of surveillance without the check from the judicial branch, that's going to be a problem. That in fact this goes to kind of a core aspect of the design of the separation of powers under the Constitution. There has to be some kind of judicial check on these activities, and the court notes that this involves some kind of prior judicial determination, some kind of judicial examination of this activity ordinarily before it occurs. The court says we can't accept, notice the government's making this argument that, look, this is really subtle, this is really complex, it moves fast, there's a high need for secrecy, and the court says, yes, all that may be true, but these are the kinds of things that courts are involved in all the time. Now, notice this final bullet here, this little quote. The case only involves, the Supreme Court said, the domestic parts of national security. It's not addressing dealings with foreign powers or their agents. We have to make that distinction constitutionally, and we have to make that distinction pragmatically. The courts are well qualified and well experienced in judging whether a U.S. citizen's constitutional rights are being unduly impacted by some kind of surveillance or evidence gathering activity. The courts are not necessarily qualified to judge the decisions made by the executive with respect to foreign powers. That's traditionally left to the executive, or a substantial amount of discretion is left to the executive in the conduct of foreign affairs. So in this particular case, the majority says that in fact the executive would have to go to the court and get an order or a warrant under appropriate procedures. Now notice this concurrence by Justice Douglas. Justice Douglas writes separately to indicate that he agrees with the majority's reasoning, but he wants to emphasize how serious he thinks this issue is. And again, this is kind of in the category of saying nothing is really new, right? Justice Douglas says, federal agents want to rummage for months on end through every conversation, no matter how intimate or personal, carried over selected telephone lines. And we can kind of see the echo of that in our thinking about electronic surveillance today.